Welcome to Absolute Trust Talk with your host, Kirsten Howe. Absolute Trust Talk brings you tips, tools, advice, and interviews to help you build a reliable knowledge base on estate planning, business, and finance to start preparing for your future today.
Hello, and welcome to Absolute Trust Talk. I'm Kirsten Howe. I'm the managing attorney at Absolute Trust Counsel. Welcome to our podcast. I'm going to be here creating another little episode in my little series about estate planning misses. And what I mean by that is mistakes, misunderstandings, mishaps that happen to our clients in the world of estate planning, and the things that we've seen, the things that we know, and maybe the things that we've learned after many years of doing a lot of estate planning and especially doing a lot of trust administration to maybe help you benefit from our experience and look at things a little bit differently and maybe do something a little differently in your own estate plan. I'm not educating you on the law as I sometimes do, or educating you on some other professional's area of expertise, but it's more like giving you the inside scoop on what we see and what we think might work in a lot of situations. Okay, so today I'm going to be talking about separate property, just as a background and not as a education point. There's no quiz on this. We are in California. It's a community property state. So community property is anything that you acquire while you are married, except for gifts and inheritances. So everything you had before you got married, that's separate property. And anything you receive during marriage as a gift or an inheritance, that is also separate property. So how this applies for purposes of this conversation, oftentimes we will have clients who they have an estate plan together, which is a joint trust, and all the other things, wills, powers of attorney, healthcare. If you're a frequent listener, you could recite that list very easily, I'm sure. But they have a joint trust. They are both the trustees of the trust. It owns their home. It owns their bank accounts, their investment accounts, all the things. And then all of a sudden, one of the partners, one of the spouses inherits a bunch of money, assets, real estate, investment accounts, whatever it is, but they get a big inheritance from their parents or some, bachelor uncle, whoever. So all of a sudden one spouse has separate property and they didn't have that situation before. And the question arises, what am I to do here? And of course, I'm a lawyer, so I already know what my answer is. It depends. What it depends on is what you want to do. So first of all, the big obvious question is, if you pass away, do you want your spouse to have the benefit of this property? So that's something. And if you want your spouse to have the benefit of it, do you want to control your spouse's access to it after you pass away? But leaving that aside, as a more practical matter, you can add separate property to a joint trust, and that doesn't change its character. Character meaning, is it separate or community? If you take your separate property and put it into a joint trust, it's still separate property. It's still yours, and you get to control who inherits it after you pass away. It doesn't change that. But when you add separate property to a joint trust, the joint trust has two co-trustees. And typically, property owned by a trust needs the participation, the decision-making, and the signature of both co-trustees. Now, you may not like that, or you may think that's not ideal. You may think, this is my inheritance. I want to be able to make all the investment decisions, and I don't want to have to get my spouse's consent or signature on all these things. I just want to manage it. I'm going to leave it to my spouse when I die, but while I'm alive, I want to be in control of it and just make it simple for me. Okay, so one possible solution is, and many of our clients do this, let's create another separate property trust for you just to hold your inherited assets. That way, you can be the only trustee. You are completely in control. You make all the decisions, and you don't need any other signature to get anything done. So that's very simple, very straightforward. And it's very easy to keep the assets separate because your separate property is in a whole separate trust where there's never going to be any doubt that that's your separate property. Okay, so that could work. But what we have seen some clients do is they have this separate, let's say you have an investment account is what you inherited. We have it as your separate property. It's owned by your joint trust, but that investment account has a slightly different title on it. It may say the John and Mary Smith Trust, John Smith's separate property. That might be the title on the account. Now, how does an account get titled? It depends on the financial institution. Some financial institutions will do this. You can make an arrangement with them. I want this titled as my separate property. And also I want you to acknowledge that I'm the sole trustee of this account, that I can make all the decisions. We don't need my spouse, and I can sign everything myself. Some financial institutions will do that. I'm going to tell you that we can write all of that in the trust document. We can say, John Smith is the sole trustee of this account. And it doesn't matter if the financial institution you're working with doesn't want to do that. They have their own legal department whose job it is to protect them from possible hazards down the road. And they may or may not, but this is what you can do. And I do know that it's possible. There are financial institutions who will do that. Clearly, setting up a separate trust, the financial institution will clearly honor that. That's an easy route, but it does involve setting up a separate trust. And some people don't want to do that. So I would say before you add your separate property to a joint trust that you already have, or a joint trust that you're thinking about creating, think about those issues. Do I really want to be in control of it, or I'm okay with having my spouse along as trustee? And if I do want to be in control, what will my financial institution say about that? And figure that out before adding it to a joint trust. All right. I hope this was helpful and that you learned something that might apply to your situation. I appreciate you listening and watching. We love our listeners. We love our viewers. We appreciate all the years that you've all been around and supporting our podcast. If you like it, like it. If you really like it, subscribe to it, and that would help us a lot. Thank you so much for watching and listening, and I look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.
This podcast is not meant to take the place of legal advice from an attorney and does not create an attorney-client relationship. If you do have a legal question or issue, please consult with an attorney.